Thank you for your attention to this brief overview of the immigration court and asylum process. Who is who? There are many groups in the immigration system in the United States. This can be confusing. We would like to tell you a little about each group and what they do. The first group is Customs and Border Protection, or CBP. These are the officials you may have dealt with at the border. They may have asked you questions about why you are afraid to return to your country of origin. They may have permitted you to enter the United States, but they do not decide whether you can lawfully remain in the United States. The next group is the Immigration Court, sometimes called EOIR. This is where the U.S. government has started an immigration court case against you. The judge in the immigration court will decide whether to grant you asylum so that you can remain lawfully in the United States. The next group is called Immigration and Customs Enforcement, or ICE. This group is like the immigration police. They keep track of people who are in the United States without papers. They sometimes arrest and detain people who have committed a crime. You may be required to go to an ICE officer for check in appointments. This is different from the immigration court. The last group is called United States Citizenship and Immigration Services, or USCIS. This group decides on types of immigration applications, like applications for immigration status, work permits, green cards, citizenship, and sometimes asylum. What happened at the border? When you entered the US, you were either apprehended from the interior of the US or you requested asylum at a port of entry. You may have been interviewed in what is called a credible fear interview about why you are afraid to return to your country of origin. Or you may have simply been given documents, including a document called a notice to appear, or NTA. Some people may have also have been given a card with the word paroled on it. These documents mean you have been allowed into the US to request asylum or other humanitarian status. It is important to understand that you have not actually applied for asylum yet. Applying for asylum requires submitting an asylum application form to the immigration court. This asylum application is called Form I-589. It must be received by the court within 1 year of your entry to the US. You have not yet been granted asylum or any permanent benefit or status in the US. For some individuals entering the US at certain points of entry, there is a new process in which you may have already been interviewed for asylum by an asylum officer and then referred to the immigration court. If you think this applies to you, your situation may be different, so please talk to the attorney about this during your consultation. Your NTA has not been filed yet. You may have been given a document called an NTA at the border. Removal proceedings officially begin when the government files the paper called the NTA with the immigration court. The government has not yet filed your NTA with the immigration court. This means your removal case has not officially started yet. The NTA contains important information such as the immigration charges against you, your identification or A number, the letter A followed by 9 numbers, and possibly the time, date, and place of your first hearing in court. If the government has not filed your NTA with the immigration court yet, the hearing date that may be written on your NTA will most likely change. You will know when the government has filed your NTA with the immigration court by receiving a letter in the mail from the immigration court telling you the time, date, and place of your first hearing, or calling the immigration court hotline, or checking on the immigration court website. So, how to check status of removal proceedings? If you have not yet received a letter from the immigration court in the mail, there are two ways that you can check the status of your removal proceedings. You can call the 1-800 hotline or you can check online. We suggest calling the hotline because it is sometimes more reliable than the website. If your first hearing is scheduled in a court located in a different city from where you live, you may also need to file a change of venue. You should get an attorney to help you with this process. If a court hearing is scheduled for you in immigration court, please call us back at 1-650-326-6440 to request a consultation. A note about ICE check-ins. You may have received a letter in the mail telling you to meet with an ICE officer for a check-in. ICE officers can require you to wear an ankle monitor or require you to send a picture of yourself every week using an application they will put on your phone. ICE check-ins are different from immigration hearings, and they are usually in a separate building from the immigration court. You must attend ICE check-ins in addition to your immigration court hearings. Updating your address with immigration. It is important to keep immigration updated with your current address. Since your NTA has not yet been filed with the immigration court, you can use Form AR11 to update your address with immigration. You can do this in paper or online. If you have check-ins with an ICE officer, be sure to give the ICE officer your new address. Even if you submit the AR11 form, you should still keep checking whether a hearing has been scheduled in your case by calling the immigration court hotline and the immigration court website. Updating your address after your NTA is filed. Once your NTA is filed with the immigration court and a case is officially started against you, it is very important that the immigration court has your current address. The immigration court will use this address to send you important documents in the mail, such as the date of your next hearing. If you move, it is your responsibility to update the court with your new address within 5 days. You can use the Form E33 to do that. If you miss a hearing because you did not update the court with your new address, you could be ordered deported. Again, if your first hearing is scheduled in a court located in a different city from where you live, you may also need to file a change of venue. You should get an attorney to help you with this process. What is asylum? If your NTA has not yet been filed with the immigration court, you can file for asylum with the immigration agency, USCIS. If the immigration agency grants you asylum, you will have status to remain in the United States and later apply for permanent residency or a green card. You can apply for asylum if you cannot return to your country of origin because you have been harmed or fear being harmed in that country if you return. The reason you were harmed or fear being harmed must be because of your race, religion, nationality, political opinion, or membership in a particular social group. Remember, you must apply for asylum with USCIS or with the immigration court if your NTA is filed within 1 year of arriving in the United States. This means that if you entered the US on December 1st, 2022, USCIS must receive your asylum application on or before December 1st, 2023. Some examples of asylum cases. These are some common claims that we see from people seeking services through our office. The strength or weakness of a claim depends on many factors, and an attorney can help assess this through consultation. Some claims that we see include people escaping domestic violence from their partner or spouse in their home country, problems with cartels or gangs who threaten family members, threats based on political activity in the home country or forced political party membership, threats or violence based on sexual orientation or gender identity, and threats based on a person's occupation, business, or property ownership. There are also many other types of claims, and a qualified immigration attorney can help assess this. Filing with the Asylum Office. As previously stated, you have 1 year from the date you entered the United States to file your asylum application. If you cannot file your asylum application with the immigration court because your removal proceedings have not begun, you can file your asylum application with USCIS. This is a different process than filing with the immigration court. For example, it is an interview, not a hearing. If your application is denied by USCIS, your case will be referred to the immigration court. It is also possible that the asylum office will forward your case to the immigration court without an interview. How do you get a work permit? In order to work in the United States legally, you need a work permit. To be eligible to apply for a work authorization, you must have some pending immigration application. If you file an asylum application with USCIS or immigration court, you can apply for work authorization with USCIS 150 days, or about 5 months after you filed your asylum application. USCIS can give you a work permit 180 days, or about 6 months after you apply for asylum, but the process usually takes longer. Some people may have a master calendar hearing while they are waiting for the 150 days after they filed their asylum application in order to apply for their work permit. If this happens, and if you ask the judge for some time to find a lawyer, the asylum clock will stop. This means the days stop counting towards your work permit eligibility, so you may not be able to get a work permit. If you are given a card that says parole on it, you can apply for work authorization with USCIS right away, but your work authorization will expire when your parole expires. It is more common to apply for work authorization through a pending asylum application than parole. Some important reminders. It is important to keep all important information and documents related to immigration together in a safe place, especially your NTA document and your parole card if you were given one. It is also important to keep copies of anything you file with USCIS or immigration court if a case is started against you. We hope you have found this video helpful. If a court hearing is scheduled for you in immigration court, please call us back at 1650 326 6440 to request a consultation.